What's happening, y'all? Counselor Curtis here. Just checking in. Today is the first day of April 2021. What a glorious day to be on Twitter. Let me tell you. Everyone is forced to consider the potential veracity or the truthiness of all the statements that are being made for the first time. A lot of people don't know what's going on. They're freaking out. So anyway, hope you're doing well. I just wanted to check in because I'm hearing about the Chauvin trial and I wanted to comment on this because I may have a little bit of insight to offer you. So, Derik Chauvin, as you know, is on trial for the killing or the alleged murder of George Floyd in Minneapolis this week, and I don't know for how much longer. But I hate to tell you this, but the reality is that if his lawyers know what they're doing, if they do a competent job at all, he should go free. He should get off. Not because he's innocent, but because of the way that our law is. And I'll tell you why. I'll tell you why and why that's a good thing, okay? So first, you have to understand that we have a system that requires proof beyond a reasonable doubt. I know you know this, but I'm going to tell you what that means, okay? Proof beyond a reasonable doubt in all criminal proceedings where someone's life or liberty is at issue. And this is obviously the case in this situation. So, he gets beyond reasonable doubt. Here, let me explain what beyond reasonable doubt it is. We have another standard, as you are probably well aware, in civil court proceedings, which is preponderance of the evidence, which is, of course, 51%. If something is more likely than not, the more likely than not case wins it. That's the way preponderance works. We have another standard in between preponderance of the evidence and reasonable doubt, and beyond reasonable doubt. It's called clear and convincing evidence. In this standard, as it sounds, the evidence can be clear and convincing. That is, you can be convinced that Derik Chauvin killed George Floyd, and it's clear, the evidence is clear and convincing, and that still doesn't reach beyond a reasonable doubt. Why, you ask? Well, first let's get to what I mean by that a little bit more specifically. Here's the best way to articulate beyond a reasonable doubt. If there is any reasonable hypothesis that is consistent with innocence, then you give the defendant the benefit of the doubt. You say, I don't believe that's the one. I don't believe that's the reality, but it's reasonable. It's a reasonable hypothesis consistent with innocence. And then you give them, then that's the not guilty right there. That's it. And it has to be that way if you think about it for a minute, because, and I'm talking about unreasonable possibilities. I'm not talking about aliens landed and, took care of the situation. No. I'm talking about any reasonable hypothesis where you could say, well, that could have happened. I don't think it happened. I don't really think it happened, but that could have happened. Then that is the doubt, the benefit of which the defendant should receive. And in this situation, without knowing anything else about the whole situation, if you know one fact, which pretty much everybody already knows, this raises reasonable doubt, and I'll tell you what it is. It is, of course, the fact that Floyd had fentanyl in his system. And, of course, if I was the defense attorney, I would ask one question of the toxicologist or the pathologist or all of them, and it would be, is it reasonably possible that the fentanyl in Floyd's system is what killed him? If the answer to that question is yes, if you believe the answer to that question is yes, then it doesn't matter all the other things that happen in the trial. You have to vote not guilty. That's what beyond a reasonable doubt means. It's the benefit of that doubt. And you want it to be that way. There's a lot of people coming out today like Chelsea Handler. Oh my God, we have a video. It's clear and convincing. She doesn't understand the standard. But from her perspective, the people I've heard say, well, change the law. If the law allows Chauvin to go free, change the law. Do you know how long it has taken us to get to the point of where criminal defendants have rights like beyond a reasonable doubt? Centuries, okay? Literally millennia. Let's just go with millennia to get to this point. of where the state, if the state can't prove with all of its resources that you did something beyond a reasonable doubt, then you should go free. That's how we have our laws. That's the way it should be, because otherwise, we know from history, minorities especially get absolutely crushed, trampled by the law. And so if you want to remove that, you know, I see people all the time talking about, oh, let's change the standards and make it easier for grand juries to bring an indictment. Listen, you don't want it to be any easier for the state. It's already as easy as it needs to be. It's easy enough. If they can't win, then they shouldn't win. That's just all there is to it. And listen, you know, think about it. The good news is the family gets $27 million. Whatever happened, you know, Chauvin, whatever you think, it's going to be fine. All right. He's not going to kill anybody else. He's not going to get the opportunity. So you don't have to worry about it if he goes free. Now, if you're thinking of rioting, if he goes free, don't. All right. Because that's a crime in and of itself. And if you do that, you should be arrested and convicted of that. So, and if you support that in any way, that's bad. You're doing the wrong thing. Don't do that. Don't support riots. You want to support the law. All of us have to suspend our belief right now of whatever it is we think we know, because we have a system which is going to determine what the reality is. That is our court system, and that's going to determine what our legal reality is that we're all going to abide by. And right now, he's presumed innocent. So we all abide by that right now. And then, when it comes down to it, we decide. And the jury decides, and then we all abide by that. If he says not guilty, if the jury says not guilty, we all should abide by that. That's just the way it is. You won't be at the trial. You won't see all the evidence. You won't see the evidence presented in a fair way. They will, and you have to trust the system. So that's where we're going with that. So good luck, Minneapolis. That's all for right now. Oh, I'll get you a little going out music. Thanks, Kevin MacLeod, for these tracks again. Appreciate it. Here are your copyrights, sir. If you have any questions about this video, let me know. I'd be happy to answer any questions. Just send me a little text. All right. See you next time.